Court is calling 2024 CR 008-663 State versus Imani Robinson. Can I have parties announced?
Galloway for the state.
David Andre Woodard from Ms. Robinson.
And are you Ms. Robinson?
Yes, ma'am.
If you review the documents entitled motion to revoke community supervision and first
We're on the
amendment
record.
motion to revoke thank you. To revoke community supervision with your attorney, did you understand it? Okay. Are you the same Imani Renee Robinson who was placed on community supervision in 2024 CR 008-663 for the offense of theft of property less than $2,500 with 2 or more convictions on December 5th, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bexar County, Texas. The defendant, Imani Renee Robinson, did then and there fail to report to the supervision officer as directed for the months of May, June, July, August, September, and October 2025 in violation of condition number 4.
How you plead to that, true or not true?
True.
Judge, we even abandon the remainder.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Judge, this is the defendant's first MTR. We are asking that the court deny the state's motion and alter and amend her conditions to include the hostility management course and a no contact order with Taylin Mackey, and that is TALIAN MACKEY.
All right. So why hasn't she reported?
Judge, when I spoke with Imani regarding not reporting, I think what happened is the new offense had occurred. She knew that she would likely have a warrant, and I think she got fearful of reporting to probation. So instead of doing what she should have done first, we're here now in this motion to revoke with months of not reporting. As the state mentioned, this is her first MTR. She has been on GPS monitor since the court set a bond for her, and she's had no issues on the monitor. So we're respectfully asking the court to follow the state's recommendation and try to get Ms. Robinson back on track so she can successfully complete her probation.
How old are you?
29.
All right, I'm gonna give you a choice. These are your only choices. There are no other choices. 1, I can revoke you, and if there's no objection, I'll sentence you under 1244 to 300 days in the Bexar County Jail. Or 2, I continue you, and as a condition of your probation, you're gonna do some jail time. And it'll be 30 days jail. Which do you prefer? You need to discuss that with her?
I would like to, Judge, before she makes a decision.
All right, thank you.
Let's go ahead and see. Be ready on Ms. Robinson.
All right, she'll come forward. We're back on the record in 2024 CR 008-663. So counsel, what has your client decided?
Which decision are you going to do? Imani?
We're on the record. Let's keep it down.
30 days and continue on 300 days.
I want to be my 300.
All right. Oh, do you have the,
I think you have turned it into your first.
all right, can I have a trial court certification, please? All right, court is finding violation of condition number 4 true. Court will sentence you under, well, the court will revoke. Sentence you to 300 days in the Bexar County Jail under 1244. Give you credit for any time served. There's to be no contact with Don and Ben's, BEN apostrophe S. There's to be no contact with Talon, I believe it's Talon McKee.
I believe that was the name the state put on the record, Judge.
All right, is there anything else with regards to sentencing?
No, Your Honor.
All right, let's review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney. Did you understand it and did you sign it?
Yeah.
Yes or no? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thanks, Judge.
Thank you.
Judge, I'm taking her to custody, right?
Yes.
Oh.
And I don't know, counsel, if she has anyone here that she has things she would like to give to them.
Yes, I thought I said, we're gonna do that. If we're not, please.
All right, the court is calling 2017 CR 13698 State versus Adriana Tanahara. Could I have parties announced?
Megan Galloway for the state.
Elizabeth Russell for Miss Tanahara.
And are you Ms. Tanahara?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Adriana Tanahara who's placed on community supervision in 2017 CR 13698 for the offense of forgery of a commercial instrument or check on August 3rd, 2018 for a term of 4 years? Is
Yes,
that you?
ma'am.
All right, state.
Violation of condition number 38. On or about the 25th day of August 2020 in Bear County, Texas, the defendant Adriana Tanahara did then and there fail to participate in the felony drug court program in violation of condition number 38.
How do you plead to that? True or not true?
Not true.
State.
We waive and abandon the remainders.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Judge Estate is asking for revocation and a sentence of 1 year in the state jail facility.
And Judge, that is our agreement, if I may speak on behalf of my
Yes.
client. Ms. Tanahara was originally placed in the drug court program. She was having financial difficulties with participation. When she was removed from the drug court program, she started to have medical issues, congestive heart failure. I have some documentation of that congestive heart failure if you'd like to review that. As her medical condition got worse, she became more and more concerned about turning herself in because she wasn't going to get her medical treatment.
Mhm.
She understands that this was not the appropriate way to handle this, and that because of that, she only can be either terminated, unsatisfied, or revoked. But she is here wanting to take responsibility, and I do think she wanted to address the court really quickly if she
Okay,
may.
do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Tanahara.
All right, your attorney mentioned something about financing.
Yes, ma'am.
How was that related to drug court?
I was just unemployed. I wasn't applying myself as I should have been, and since then,
No. Because it seems as though maybe a conversation that you've had, you're saying that you had issues with finances in felony drug court. And normally felony drug court does not require you to pay the $1,000 fee until you're closer to graduation. So I'm wondering, just so I'll know,
Mhm.
what finances are you saying you had difficulty with in felony drug court? Because they help you
No, I
with
didn't have
employment.
it. And not in the drug court. I had it
No.
in the program, I guess, that they offered me the last,
What program?
My probation officer had called me and told me that there was a program I could pay off my fees in a certain amount of months. And
What program?
I don't know what it was called.
So two things, Judge. How I was addressing the drug court was that she was not able to provide for herself, not provide for the drug court
Okay.
because of financial issues. So that's issue number one.
You know,
Um,
I guess.
And then issue number two is that according to my client, the felony probation officer told her that if she was able to just pay off her fees, they would terminate her from probation. I know that that's not necessarily the way that it works, but that's how it was discussed with her. And it's not the first time I've heard that being discussed with a client. So I think just for court's clarity, I think that's what she's speaking about.
Okay.
And let me give you the documentation on the medical.
And then my other question is, it said that you owed $743.99 to HEB. Has that been paid?
Yeah, ma'am.
I'm sorry?
No, ma'am, not yet.
All right,
It was
you've
this week.
had since 2018 to pay that. Why hasn't that been paid?
I wasn't always employed, but you know, that's my fault.
But I mean, it's since 2018 and you haven't paid a penny to that?
Um, take
That's a problem.
responsibility. Yes, ma'am.
And then this is not your first motion to revoke. That's a problem.
Understand.
So what have you done? Have you done anything other than this is your second motion to revoke?
I've just got employed. I mean, I've just, been trying.
I mean, if you haven't done anything, I mean, just tell me.
No, ma'am, I haven't done anything towards the courts. You're right.
Because you were placed on probation before I was presiding judge in this court. And then you had a motion to revoke, and it was violations of 5 and 5. And according to this, you have children. That's why I told you to do parenting classes.
Right.
And it appears you haven't done anything since 2018.
Sorry.
I mean, I don't even know. Somebody explained to me why I should give you a year instead of 2 years because you haven't done anything.
I guess the basis of our request is the congenital heart failure and the medical treatment that she would receive in the state jail facility. She hasn't done anything towards the court, but she did at one point receive gainful employment, and that was a huge struggle and a huge hurdle that had to be overcome by Ms. Tanahara. I think you can see based on her drug court participation as well as even the medical documentation, she is a methamphetamine addict and has struggled with addiction for quite some time. And so even just getting gainful employment was a feat in and of itself.
And who's taking care of your child?
I think it's her mom. Is that
That's my sister.
your sister? And they're here, Judge.
So does anybody want to tell me why I should just give her a year? She hasn't done anything. I mean, not even paid towards HEB since 2018.
And so our request would be based on the medical issues as well as the fact that she did seek gainful employment. We understand that this is not the way Ms. Tanahara should have handled this. She understands that.
State.
Judge, I did take into consideration the medical issues, which is why the state is asking for 2 years on this.
All right. Are you asking me to follow this revocation for 1 year?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, this is what the court will do. The court is finding violation of condition number 38 true. The court will grant the motion, revoke, sentence you to 1 year in the state jail facility. Give you credit for any time served. There's to be restitution to HEB in the amount of $743.99. And that's under cause number 2017 CR 13698. There's to be no unsupervised contact with minors. And the court will request the therapeutic community for you. Therapeutic community doesn't increase the amount of time that you will serve, but it is designed to help you with any addictions you may suffer from.
On my way out of my room.
During that the therapeutic community is in the state jail facility.
All right, did you review the document entitled Profit Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. With your heart condition, if you continue to use, meth is not great for the heart to begin with, not even on a healthy heart. One or two things going to end up happening. Either you're going to be in and out of jail or in and out of prison for the rest of your life, or either you may get a bad batch, or it may hit your heart a certain way, and somebody's going to have to identify your body. If you're not going to be clean and healthy for yourself, then do it for your child if you love your child. And when you're released from the state jail facility, don't come to your sister's home acting like you've been the parent all the time and you're setting your own rules. You're going to need to flow with the way the household is set up. Do you understand?
Yes, ma'am.
All right, when you're released, if you cannot find a place to help you with your sobriety, any type of transitional home, if I'm still here, you come back here, I'll pick up the phone, call a place to help you, all right?
Appreciate that.
All right,
Thank you.
good luck to you, okay?
Thank you.
You're welcome. And Joseph, your client, he doesn't need anything on the record, does he? All right, so I'll let you all take that up. Thank you. Hi. All right, Merry Christmas, Happy New Year, Happy Hanukkah, Happy Festivus, Happy Kwanzaa, Happy Holidays. All right, court is calling 2025 CR 010795 State versus Randy Gonzalez. Can I have parties announce?
Good morning, Judge. Alfonso Cabañas for the defendant.
And are you Mr. Gonzalez?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Rodriguez, did you review the true bill of indictment with your attorney? I'm sorry, Mr. Gonzalez. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, you understand to proceed on the lesser included offense of possession of a controlled substance, PG one less than.
Any objections? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance? Penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he did.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense of possession of a controlled substance. penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 180 days in the Bear County Jail under 1244 and an $800 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I do.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Yes, Your Honor, state offers states exhibit 1 in all.
No judgment states one in attachment five.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just that we ask that the court follow the plea agreement we have with the state.
All right, the court will find you guilty. The court will sentence you to 180 days in the Bear County Jail under 1244. There's an $800 fine, time and money to run concurrent, and there's to be no residing in households with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You need to make sure that you get sober, because if you don't, only 1 or 2 things going to end up happening. Either you're going to end up spending your rest of your life in prison, or either you're going to end up where somebody's identifying your body. You understand?
Yes, ma'am.
All right, and he also has another case. Is that correct?
I believe so, Judge. I'll double check.
All right, it's family violence,
Yes, Your Honor, who is the defendant?
Is he Freddie Lozano?
No,
No.
Your Honor.
Oh, why did I do that? It's Gonzalez.
Randy Gonzalez?
Randy Gonzalez. Oh, he doesn't have anything else.
Okay.
All right, so with regards to your sentencing, when you're released from custody, if you can't find a place that can help you maintain your sobriety, you come back here, I'm here, I'll pick up the phone, call somebody to put you in their transitional home. Do you understand?
Yes, ma'am.
Because it's not going to go well for you if you don't take control of this.
I
All
understand.
right?
Yes, ma'am.
Okay,
Thank
good luck to you, okay?
Judge,
Yes, ma'am.
one more thing, Judge.
Mhm.
On the court's condition that he does not reside in a home with a minor, his daughter lives with him, Judge, at his home.
Mhm.
Could the court make an exception just to let him?
Here's my concern. And I would be willing to change it, but he needs to show that he's going to be clean and sober, because I have a concern with
Mhm.
people who are in the throes of their addiction residing in households with minors, because anything can happen, right?
Yes,
And by anything, I mean, you don't want your child to discover you overdosed, right? And I've had cases as an attorney, I know your attorney has had cases as well, where children find their parents and they've overdosed. That's not good for their psyche. That's something that's always with them. So if you show the court that you've maintained your sobriety, your attorney comes back, I will remove that,
Yes, ma'am.
okay? That's completely up to you. All right?
Yes, ma'am.
Okay, good luck to you.
Thank you.
Thank you, Judge.
Thank you, counsel. Yes.
Question on,
Court is calling 2025 CR 012760 State versus Brendan Marcus Andrew. Can I have parties announced for the record for the state?
McBain for the state of Texas.
Defense?
Stephen Harkowitz for Brendan Andrew.
And are you Mr. Andrew?
yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Andrew, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with continuous violence against family member. Against the family. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Andrew, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Counsel, has your client been able, excuse me, there's no hugging up in this courtroom. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Andrew, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, there's a $1,500 fine, affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor. State is recommending deferred adjudication.
No, is that your plea?
Yes.
All right, did you review that's okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Counselor, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be 100 hours of community service restitution, the BIP course, the TAP evaluation, and follow all recommendations. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, I do.
Then to the offenses charge, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence as exhibit 1 with all attachments. No objections, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Okay, off the record, I don't see the February 2nd date on this.
On the last page, Your Honor. The last report is the February 2nd one.
Oh, thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the recommendation that the state has made and grant Mr. Andrew deferred adjudication, Your Honor.
All right, what are your issues with anger?
Mine, it's gotten a lot better since the incident, but I will admit before the incident, I would just allow my emotions to get the best of me. And instead of just kind of thinking of different outlets like I do now, whether it be going on walks, going to work out, going to just kind of clear my mind, listening to music. For me, I would just allow myself to fly off the wall. I would just allow myself to just react and it was one of those act now and not really think about the repercussions later. And so due to that, I will admit that kind of undisciplined part of me ended up coming out the nights of the incident. And sadly, that's why we're here.
Are you employed?
As of this morning, no, ma'am.
Okay. Do you have any children?
No, ma'am.
All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's a $1,500 fine that will be probated. There's an affirmative finding of family violence. There should be no contact with Janelle Ota. Proof of employment within 45 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. The BIPP course. Field visits 1 time per month until further notice. No residing in households with minors.
I will say I apologize. I do have a roommate and she does have a kid. She has a daughter that stays with us.
Yeah, that's not a good placement.
Yes,
And you say it's a roommate. What's your relationship?
it is. It's just a roommate type of situation.
And is she aware of your criminal history?
Yes, ma'am.
I don't understand that, but yeah, I can't allow you to reside in households with minors until you have at least taken some steps or some classes with the BIPP course.
Absolutely.
I'll consider after that.
Yes, ma'am.
All right, there's to be TAP evaluation. In custody. Follow all TAP recommendations. And there's to be referral to felony drug court. Probation, is there anything else? Yes, probation. Anything else?
No.
All right, is there anything else you need from the court in order to be successful?
Not at this time. One thing that I was wondering is I'm currently working towards my CDO. And so once I finish that, I know sometimes some jobs can take you out of state, some will keep you in Texas.
And so we'll cross that bridge when we come to it.
Yes, ma'am.
And with regards to the 100 hours of community service restitution that I'm gonna order, if you complete and obtain your CDL, that will satisfy that condition.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am, I do.
All right, and there's,
Should be long.
all right, just give me a moment. If he'll have a seat and then we'll do the victim impact.
Find you such.
Throw it.
They're talking about in custody.
Yes, Counsel.
Just.
and he's gonna be in custody.
The courtroom fell silent as Brendan Andrews stood before the judge facing a devastating charge of continuous family violence. His voice trembled while admitting how uncontrolled anger destroyed his life. The judge listened closely, delivering a firm but compassionate warning: 5 years of deferred adjudication, strict probation rules, mandatory counseling, 0 contact orders, and a complete weapons ban. When the judge rejected his living arrangement due to minors in the home, the reality hit hard. One wrong move could send him straight to prison. The moment turned painfully emotional as the judge emphasized discipline, accountability, and personal transformation. This was not just sentencing, it was a final chance at redemption. In a chilling moment, the judge delivered one of the most intense drug warnings ever heard in court. After sentencing the defendant for controlled substance possession, she leaned forward and spoke directly, "Continue using drugs, and the only outcomes will be prison or death." Her words echoed across the courtroom, "The last time you use may literally be your last." She didn't stop there, offering personal support, promising to personally call recovery centers if the defendant chose sobriety. It was raw, emotional, and unforgettable, a judge fighting for a life before it disappears. Tomas Cantu's case moved quickly, but the message was deadly serious. Charged with drug possession, he accepted a plea deal, 6 months in county jail, fines, restitution, and severe restrictions. But the judge wasn't done. In a heartfelt warning, she told him his drug addiction was already damaging his heart. If he didn't stop now, jail would become his permanent home. She offered help, guidance, and recovery support, but reminded him the choice was his alone. It was a powerful moment of justice mixed with compassion. Tension exploded as attorneys rushed against the clock, juggling paperwork, jury trials, and plea deadlines. Unexpected delays, frantic negotiations, and scheduling chaos unfolded live in court. One mistake could trigger a full jury trial. The judge maintained strict control, pushing attorneys to finalize decisions quickly while managing courtroom pressure. It was a rare behind-the-scenes look into real courtroom stress where every minute, signature, and decision can change a defendant's entire future.